Hi everyone, Lee Pacchia here, and we're talking about the situation at the New York Times today. Last week, New York Times owner Arthur Sulzberger fired executive editor Jill Abramson. There are a lot of conflicting theories as to exactly why, but an early report from the New Yorker's Ken Auletta said an equal pay dispute was at the heart of the matter. I'm joined now by Gary Friedman. He's a partner in Weil, Gotshal, and Manges' national employment litigation practice. Full disclosure, Weil is a Mimesis client. We're thrilled to have Gary join us. Welcome.
Good to be here, thank you.
So this dismissal has sparked an awful lot of controversy. I have to ask, have you ever seen anything like this in your career?
The media frenzy is somewhat reminiscent of the Mark Hurd situation at Hewlett Packard a few years back, and the facts and scenario are different, but the media attention and scrutiny has been similar. However, I think that there's much more polarization with respect to the attention that this issue was getting at the time.
Well, for sure. Let's assume for a moment that Ken Auletta got this right. Jill Abramson raised an equal pay issue. She got a lawyer involved, and she was subsequently terminated. Did the New York Times fall short of its legal obligations here?
Well, in terms of, and again, all we know is what has been printed. Frankly, it seems that more has been coming over the last week or so from the New York Times than from Ms. Abramson's camp. And perhaps that's to her credit that she is waiting for an appropriate time in which to discuss the issue more fully. But that said, clearly this came as a surprise to virtually everyone in the newsroom. The issue that's receiving a lot of scrutiny is the proximity of the raising of the equal pay issue with the termination, and that, as in many cases, arouses a lot of questions as to the timing and then the merits of the decision. That said, a fair amount has come out over the last week or so to put some meat on the bones, which was missing in the first 24 to 48 hours.
There's been a lot of focus on whether or not she got paid as much as her predecessor, Bill Keller. Can you talk to us about how a company can make sure that these successor compensation plans don't run afoul of labor and employment law?
Yeah. Dealing with issues of pay is complicated because I sometimes analogize it to running a relay race where you're handing the baton off, and at the point at which you catch the baton, you may be 20, 30 strides behind the next person. The tough element of pay is that it has a long tail and it has a history associated with it, and you take that history with you wherever you go. Now, my understanding is that Mr. Keller had been at the Times for a longer period of time than Ms. Abramson. Moreover, there were certain factors, for example, I think the pension plan was frozen in essence in 2009, and in terms of total compensation, variable compensation such as stock options and incentive compensation such as bonuses would vary depending on the fortunes of the New York Times.
Yeah, this situation presents a really tricky situation for anyone running a large company. If a CEO or stakeholder wakes up one day and says, my God, we've been paying C-suite executives way too much money, we have to get this under control, how do you handle lowering the amount of C-suite level comp for people who are coming into new roles? I mean, they have to worry about issues just like this, right?
That's absolutely true, and it's tough to put the genie back in the bottle. I mean, if you were to wake up and find out that you were arguably overpaying vis-a-vis the market, it probably would be a disaster to start slashing and burning at that point in time. You're going to have to do it in a more measured way because you're going to have a morale problem on your hands. Good luck recruiting anybody at the C-suite level for a while if that's the case. And so what you're going to have to do is it's going to have to be more of a gradual process, which is actually something that may have been at play here. Where perhaps the separation, if in fact the big issue was Ms. Abramson's failure to tell Dean Baquet that the woman that she was recruiting was for a comparable position, and if that had been off-putting to Mr. Salzberger, it's possible that this scenario could have been drawn out in a way that was less abrupt.
The legal issues here are one thing, the optics are quite another. How can large companies engage with the public in situations like this, or how should they?
I think that what Mr. Salzberger seems to be doing is he did not want to keep his head low on this one. Once there was a frenzy over this, and the inference was drawn that perhaps there was a relationship between Ms. Abramson raising the issue of pay and her termination. I think in light of the fact that the New York Times has a long tradition of supporting inclusiveness, certainly on their op-ed page, and Mr. Salzberger, I believe, has a track record in that regard that's favorable. It was important for him to make sure that he corrected the record, at least the way that he saw it. And to actually take the proverbial journalist no comment would have been a public relations disaster.
Right. Gender issues are becoming more and more important these days. Are there issues beyond equal pay that fall into the area that companies need to be thinking about? Which ones specifically should be at the top of their list?
Yeah. So just staying with pay for a second and then moving on to other areas. I mean, the Obama administration has created the National Equal Pay Task Force. There's been a lot of focus, as I'm sure you know. The Paycheck Fairness Act is something that has been trying to work its way through Congress. So one of the highest initiatives in the Obama administration is a focus on gender and pay. Beyond that, however, there are all sorts of issues relating to promotion and glass ceiling. There are also issues that are really now becoming prevalent with respect to caregiver situations. So, for example, it looks like in New York City, they are contemplating enacting legislation that would create a separate cause of action. No such cause of action exists at the federal level protecting caregiver status. By caregiver, we're talking about men or women with children, or men or women who are taking care of someone, and they would have, in essence, a separate cause of action. Right now, there is no separate cause of action for caregiver discrimination. It is part of Title VII. It's something that the Equal Employment Opportunity Commission has made a systemic priority to focus on, because there are, unfortunately, a lot of gender stereotypes about women's commitment to work for those who are the primary caregiver. And one of the things that's appropriate for extinction is eliminating any sort of stereotype in that regard.
Listening to your answer, it sounds like there's going to be a lot of new legislation and new laws and regulations in this space coming online in the future. 5–10 years down the road, not to get too granular here, what is that landscape going to look like? Is it going to be one of increasing complexity?
It will be. If you take a look at even the sick leave legislation that has been enacted in a lot of cities, and particularly New York lately. And maybe this ties in with the issue that was at least attributed to Ms. Abramson as it relates to her management style. Life has changed dramatically. Companies are looking more to accommodate different work styles. Obviously, working from home is much more palatable than it was even 10 years ago, and therefore sort of the sharp lines that were created 15–20 years ago about your need to be in the workplace, your need to work a certain number of hours a week, your need to be working nights and weekends have changed. And so therefore you've got a much more flexible workforce. You've got people who are very, very talented and very bright and very successful, but who also have demands. And they may be the primary caregiver. There may be illness factors at play here. And one of the great developments has been that there are laws now that are more accommodating of those different work styles and those different issues that people have to confront.
This is a big story with a complicated issue at the center that's garnered a lot of attention over the past couple weeks. You've probably been on the phone quite a bit recently. What are you telling your clients? Is this a teachable moment?
It is a teachable moment in the sense, and actually a variety of senses. One is, and I have no idea whether the New York Times conducted their own internal audit with respect to pay issues. It is important. Self-critical analysis by companies is really essential to finding out where you stand. And once you find out where you stand, if some corrective measures are necessary, then you implement them. However, the one thing to be mindful of is there are many lawful reasons and explanations for disparities in pay. It can include, obviously, experience, education, times out of the workforce, et cetera. There are many factors. They're often called the human capital factors. And those have to be analyzed. And it's very easy to look at some facial disparity and say, we have a problem. First thing you do is you have to assess if you have a problem. And once you determine that there may be an issue, you have to correct it. So I think that you're going to see a lot of changes. In terms of other teaching lessons, I think what rubbed a lot of people the wrong way was the manner in which Ms. Abramson was exited. She clearly was a luminary in the field. She had brought a tremendous amount of continued gravitas to the New York Times. And I think that even her detractors were struck by the brusque manner in which the separation was handled. Now, there may have been reasons for it, but both in the newsroom and outside the newsroom looking in, it looked harsh.
Are C-suite terminations to be handled differently than regular terminations? I mean, the optics, I would imagine, are a little bit more complicated.
The optics are more complicated, although I would start with the baseline that you should try to treat the terminations the same way, because if you get into the mindset of, well, those below the C-suite don't deserve our attention, you're going to have a lot of problems. That said, it is much more complicated. It's much more complicated because a story needs to be told. If you're a public company, you have to have an explanation. And abrupt terminations raise the specter of something potentially problematic at play. Is it the specter of fraud or misappropriation or plagiarism or something like that? And that's why for both parties, and that's why I can understand Ms. Abramson's position, inferences might have been drawn as to, well, maybe something was going on that's not apparent to the eye, and that's not good or fair or right for her reputation. Similarly, from the New York Times' perspective and from an employer's perspective, you don't want inferences to be drawn about the nature of your executive and perhaps, particularly when you're a public company. Is there something that the shareholders should be worried about? And that's why I think at the end of the day, there generally is a need to have a comment period, but a controlled comment period.
Awfully complicated stuff. Gary, thanks so much for stopping by and helping us sort through it.
My pleasure. Thank you.
That's Gary Friedman from Weil, Gotshal, and Manges. If you'd like to see more of the stuff we're working on, be sure to go check out our YouTube channel, and you can always follow us on Twitter. I'm Lee Pacchia. Thanks for watching.